The succession planning mistake number 3, the failure to put legal documents in place to allow key persons to take over new responsibilities and designate who will be president if the owner-president dies or becomes disabled. Every business has a legal structure. Some, you have already identified these things and the things are in place. Let's talk about the different types of legal structure that you have as that your business may be structured as. You may just be a sole proprietorship. You're not a corporation. You're not a limited liability company. You have no asset protection, so to speak. And so, who's going to run your business if you are just a sole proprietorship with no legal entity behind you? Who's going to run your business? The answer is the person that has your power of attorney, your financial power of attorney. A lot of times we'll do a springing power of attorney for people that says that when I'm disabled, the power of attorney springs into action. I've identified who's going to be running the business. Now, for some business owners, you may have key people working with you, and you may be married, and your spouse has your power of attorney, so all of a sudden you've identified your spouse is going to start running the company. And your spouse is going to tell your key people what to do. And if your spouse doesn't like what they do, and what I'm trying to say to you, that may be the worst thing you could ever do. You may want to provide, depending upon your personal situation, that the spouse is going to handle your personal finances, but John or Mary is going to be involved taking over the business because they're key people. That's who the customers are working with. That's who the people that you work with, all the relationships you have. And that person's going to be having to make the decisions because you had a car accident and you're out for a month. So again, it's your power of attorney that you need to identify who's going to control the business if you die or become disabled, if you're a sole proprietorship. If you're a limited liability company, you can either you're either member managed or manager managed. Now, a lot of people don't even know that. They're a limited liability company, and they don't know that that's not a tax entity, that a limited liability company can be anything. It could be, if you're one owner, you're a sole proprietorship. If there's two owners or more, there's a partnership. You can elect to be an S corporation, or you can elect to be a C corporation. So an LLC is not anything other than what you elect it to be. But it is recognized under state law. And so if you do not have an operating agreement, a written agreement identifying how the owners are going to operate the company, state law has provided that you are treated as a general partnership, and any member can conduct business on behalf of the limited liability company. You are member managed. It's like you're a general partnership, and any partner can act on behalf of the company and do anything. You may not know that if you got 3 partners, that if you don't have an operating agreement designating a president of the company or a manager or something, then any partner can do anything they want, and under partnership law, you've obligated the business to that financial obligation. Okay? So you have to first determine whether you have an operating agreement or not, which you should know. If you don't, you're member managed. If you do have an operating agreement, and this is what Amy and I and Kurt do, we have a checklist we use to put together a good operating agreement. You can get that from us if you want to. If you don't have one, you need one, just contact us and we can give you that checklist. But if you have an operating agreement, typically you're trying to provide, here's the president of the company, here's the vice president, and so you have a succession in line in place. That's like a corporation. So it gives you the same structure that you have in a corporation, except the corporation is a little bit different. I'll cover that next. But at least you're going to identify in the operating agreement who's going to be taking control of the company if something happens to the president, and how that's going to operate, and how, if you have more than one partner, how that's going to operate. If you have more than one partner, is it going to be unanimous, or do you need 2 out of 3 or 3 out of 4, or how are you going to handle this? That's part of your strategy when you start putting together a good operating agreement for your business. Let's talk about a corporation. Let's say you have a corporation that you own. Not a limited liability company, but you have stock in a corporation. You would have a power of attorney that if you own the stock in your name individually, whoever has control of your financial power of attorney will control the voting of your stock. So a corporation is set up that the shareholders of a company appoint a board of directors typically annually. There's an annual meeting. And then those board of directors appoint a officer of the company. You have got to follow these corporate formalities. You've heard of piercing the corporate veil. If you don't follow those corporate formalities, you have personal liability potentially in a lawsuit for not operating the corporation properly using a shareholder meeting, a board of director meeting, and appointing officers. So you need to have those corporate minutes. And we'll provide those to you too. That's boilerplate stuff, quite frankly, but they need to be done annually, theoretically, to have liability protection. However, if you do some good estate planning and maybe you put your stock in your trust, we have our clients, we recommend a trust, and we'll be covering that in the third segment, estate planning. Then the trustee of the trust will have control of the stock. And the trustee of the trust then will be in control as a shareholder to appoint the board of directors, or to the board of directors then to appoint the officers of the company. What I would try to share with you is that I think you need to go through this process. You need to have the legal things in place, but you need to do the planning to direct whoever you put in charge what you want them to do. Now, keep in mind, they might choose to do something else. So it's a matter of trust sometimes, whether it's family member or key employee.